Number 122, people of the state of New York versus Damian Jones. Counsel?
Good afternoon, Your Honors, and may it please the Court. My name is Scott Danner. I'm joined at counsel table by Rosemary Herbert from the Office of the Appellate Defender. We represent the appellant, Damian Jones. If I may, I'd like to reserve 3 minutes rebuttal.
3, sir, you may.
Thank you, Your Honor.
So does an ascertainable structure require a boss at the top?
An ascertainable structure requires a system of authority. That may take the form of a boss at the top. It may be hierarchical, but I don't think hierarchy is necessary to the existence of authority. And I do think authority is necessary to having a criminal enterprise within the intention of the statute.
What about
I'm a little
coordination?
confused. What does that mean? That let's say there were 5 people that we're talking about, and they all shared equal authority, you would say that's an ascertainable structure? Or do you mean there have to be ascending levels of authority?
I think the former case may fit the statute. It's not what we have here, but there, as long as there is an exercise of and a submission to authority, that's where you start to get the dangers that the legislator specified in the legislative findings.
That means there's somebody below the 5, is there not? That's not just the 5.
If it's, yeah, certainly in that case. I mean, I think even the classic mafia cases, you have this commission of the 5 families, and, you know, they're all equals around the table. Obviously, their decisions ramify down through the ranks.
Yeah, they have underlings. Yeah.
Exactly. And, you know, you can picture a law partnership, not to conflate the two.
Well, that's
but
what I'm trying to understand. What's the system of authority that doesn't have ascending command or supervision? That is what I'm trying to understand.
Sure, and you know, ultimately there may not be, you know, again, because this case doesn't involve any authority, whether hierarchical or not, in a way, that may be a question for the next case. But what is essential is that there's somebody giving directions and that those who are alleged to participate in the enterprise are taking directions.
Well, in a classic partnership, common law partnership, there's no one doing that, is there? I'm wondering what you mean by authority.
Sure. By authority, I mean essentially the power to direct. So it's true. In a classic partnership, there's equal.
Everybody has equal power to direct.
Governance rights. But nevertheless, the partners agree and submit themselves to the partnership. They agree to work and dedicate all of their efforts for the partnership. There's a distinct entity.
But each of them has the ability to bind. Each of them has the ability to bind all the partners individually. They're not relying on a vote or a majority or anything like that.
That's also true, but I think to be a partner and to enter a partnership, there has to be an agreement to carry out the partnership's work. And when you don't have, and so that's something that binds them together. And it may not be a hierarchical authority, but that's a pretty easy case in some ways because you can point to the partnership as the entity, the distinct from the pattern of activity entity to which people have submitted themselves and for whom they act. By contrast, what we have here are individuals who act at their own direction and for their own benefit, not to benefit any distinct entity.
But to go beyond the phrase of ascertainable structure, it seems that there was proof in the record, not of a hierarchical structure, and I wonder if that's necessary at all, but of a continuity of existence, and to quote the language, in a criminal purpose beyond the scope of any individual, let's say, motorcycle theft in this particular case. There seemed to be proof in the record for that.
Well, yes, Your Honor, but note that continuity is a distinct element of a criminal enterprise. You not only have to have continuity, you also have to have the ascertainable structure. Certainly, for example, in People versus Western Express, it wasn't 1 or 2 stolen credit card sales. It wasn't an odd.
Ascertainable means to me understandable. That doesn't mean hierarchical. I guess ultimately the question for us may be, and you can respond to this, is that what's the difference between an ascertainable structure and a market? Because you could argue that this is a market, or you could mark that all markets are structured, however. So where are we drawing the line?
Exactly. I think your Honor's hit on it. The difference between a market, or one difference between a market and an ascertainable structure of the kind targeted by this statute, specified in the findings, is that a market is one in which, although things are organized and may be quite coordinated and complex, what's causing that coordination and complexity is individual self-interest or market forces, supply and demand. When that is the cause of coordination, that is not the danger the statute exists
No,
to
the court
target.
instructed the jury here, though, right, that what was necessary was coordination plus collective decision-making. Do you agree with that?
I don't think
In
that...
the absence of hierarchy.
I don't think that is sufficient, at least in this case, and here's why. Because what the coordination and collective decision-making constituted here is, that's akin to me going to Starbucks, buying a cup of coffee, and saying the barista and I collectively decided that I was going to buy a coffee and he was going to sell it to me. If that's all you just have a description of a pattern of criminal activity, and that is not enough. Western Express makes clear that is not enough. We could have characterized the purchases and sales in Western Express as collective decision-making and coordination, but we know that this court dismissed the indictment there. On the other hand, if coordination is caused by a distinct entity with authority and the collective decisions are imposed and enforced, now we're in the world of a criminal enterprise of the sort imagined by the statute. That's what distinguishes.
So you're saying they could all have an understanding of how they're going to function, and they're all at an equal level amongst one another? It's totally egalitarian, very democratic?
I think in a way a market is very egalitarian in the sense that you can take it or leave it. You're at arm's length. The sellers set their prices. The brokers set their commissions. The buyers took it or leave it. That's certainly egalitarian in the sense that nobody's making them do deals with one another. But that's nevertheless certainly not an enterprise within the meaning of the statute. And again, we just point to Western Express to know that.
El Chapo's drug trade is a market. No, I mean, there's buyers and sellers, and that's what determines the price.
Right, but there's also enforcers and bosses and underbosses.
There's
and
lookouts,
these are the
there's
people,
lookouts here and middlemen here, and different names, but...
Well, they're in the sort of classic case of a drug enterprise like that. You have people working for, employed by, and following the instructions of the enterprise, kicking up profits. If you take El Chapo's drug empire and then you look at an addict on the outside buying drugs, we wouldn't say that the addict is in the enterprise. You've drawn it too broadly at that point. For example, in Western Express.
Well, that person's buying the product of the enterprise.
What about
I
someone's-
thought Judge Wilson was referring to these other kind of perhaps lower-level players or external players.
I think if those lower-level players bind themselves to the enterprise, submit to the directions, take the directions, act for the benefit of the El Chapo organization, you've got it. You've drawn the enterprise where it
These guys
belongs.
were all specialized, right? I mean, doesn't that count for something? You had the guy who was expert at stealing and scrubbing the bikes, right? You had the guy who had the connection to your client. We had the distributors, and we had the person with the contacts to distribute them. Doesn't that count for something?
Specialization, again, can't just be a description of complex criminal
But they
activity.
couldn't operate without each other.
Well, certainly, I think in Western Express, you have the buyers who had the method of stealing the credit card information. You had the broker who dealt in cryptocurrencies. You had the ultimate sellers of it, right? So, and there, what the court found was that was a description of a pattern of criminal conduct, and that does not meet the distinct requirement of the structure. Now, if there's somebody saying you're going to be the thief. Here, I instruct you to go out and do that. You go out and do this. Now we start to have someone who is removed from the street-level crime. That's the insulation referred
One
to in the
person
statute.
has to occupy that spot?
Not necessarily. What's essential is that some either person or a group or partnership, somebody or something distinct from just an observation of the crimes themselves is doing the directing.
Well, the bike that was stolen on order fits that description. Now, I realize that doesn't involve Mr. Jones.
Sure, Your Honor, and there's evidence in the record that I think does likely meet the enterprise requirement, but it pertains to a small subset of the market here. That's Dwayne White's steel crew. We talk about this in the brief. There's evidence of giving orders. There's evidence of sharing profits, but that pertains to a small subset. And when you start generalizing and you charge a citywide market as the relevant enterprise, you've broken the one thing that bound everyone together and made it an enterprise in the first place. The respondent asks, if we have Dwayne White's crew, Why doesn't adding the brokers and the buyers, why doesn't that make it more of an enterprise? That's like asking if I have a triangle and add a fourth side, why doesn't that make it more of a triangle? You've
Thank
taken
you.
away the thing that made it what it was.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honor. May it please the court, my name is Ross Mazer for the respondent, the people of the state of New York.
So what's an ascertainable structure that doesn't have a hierarchy? A non-hierarchical ascertainable structure, what would that look like?
Just to start with the statutory text, the second element of the definition of enterprise corruption from Penal Law 46010 subsection 3 requires that the criminal enterprise be associated in an ascertainable structure distinct from a pattern of criminal activity. And this court, in all of its decisions from Western Express through Concharla through Keshner, has interpreted the phrase ascertainable structure to require and I'm quoting here, constancy and capacity exceeding the individual crimes. Case law has elaborated.
For those cases, there's a separate business, whether it's the web business or the medical center. I mean, there's a separate business. Right? They're all tied to that business in some way or another, so it's obvious in that way, right?
So in cases where, like here, where it's a purely criminal enterprise and it's not linked to an otherwise legitimate enterprise, like in the federal system where we talk about associations in fact, there are a host of factors that determine whether an ascertainable structure is present. For one thing, the duration that the enterprise has existed with a relatively stable group of people. This investigation lasted for 16 months, but the leaders of the enterprise, those who were identified in the indictment as the distributors, professed that they had been in the same business for up to 5 years.
So if in Western Express it had been the same people for 5 years, would it have come out differently?
No.
Why not? Well, how do you distinguish that case?
Well, on a number of levels, but for one thing, Western Express made no effort to control access to the market. Anybody who had access to a computer could log on and go onto Western Express's market and either sell or buy illegal data. Here, on the other hand, this was an enterprise who took great pains to control who was a member and who was not. And we saw, at various points, I'll just cite a couple of examples. In one case,
You mean the people that were finding the buyers wouldn't have accepted anybody who came along and said, I've got a stolen motorcycle? What evidence is there in the record of that?
well, it's true that they may have dealt with outside suppliers who were not members of the organization. However, in one instance, for example, Mills, who was a SEAL team leader, admonished Cadet, the last name of a member of his SEAL team, for doing a favor for a friend by selling a motorcycle to Paul, one of the distributors.
To what consequence? What was the consequence? Was there a consequence to the person being admonished?
He said he would not do it again.
I'm having a hard time. I'm having a hard time with what we have here, distinguishing it from any kind of market. If these were legal motorcycles, right, and or some other product that you were trying to create a market for and get buyers and sellers and people that would fix it up or clean it up or whatever it might be, how is this any different from any market, black or not black market?
Well, it's certainly true that a black market exists for stolen motorcycles, and that this was a distinct entity that operated within that larger market. And I think this goes back to Judge.
One of the things I'd look for, if there is a discernible structure, it would be competitors, people doing the same thing within the market. Were the competitors here?
I don't think there's evidence in the
Were
record
there
one way or the
identifiable
other.
competitors with different names and different organizations? I didn't see any proof like that at all.
I don't believe the record touched on that one way or the other.
So getting beyond this, what's the proof that this defendant was aware of the existence of the criminal enterprise and participated in it?
So there's a lot of evidence that we discuss in our brief, and I probably can't catalog all of it, but I would like to highlight just a couple of elements that I think refute or completely belied the defense counsel's suggestion that what we have here is really a defendant who was just involved in selling 4 motorcycles on 3 separate dates. For one thing, the October 4th, 2011 transaction did not involve any of the elements that defense counsel says, that defense counsel refers to. For example, the defendant himself was not at that sale, which occurred to the undercover officer. Neither was Dawson, the cooperator and the defendant's principal contact. Instead, Dow, who was one of the distributors, one of the leaders of the enterprise, and another member whose name was Trochezi Ngundu, sold a stolen motorcycle to the undercover officer, which was linked to defendant because the VIN number was actually registered to him.
Fake VIN number.
It
was not the VIN number that belonged to that bike. It belonged to a different bike that the defendant owned.
Absolutely. So the VIN number was registered to him, but it didn't match the engine number, it didn't match many of the other parts, which only further demonstrated that defendant had access to the store of spare motorcycle parts that this enterprise obviously used as a chop shop.
Counsel, what's the difference between a conspiracy and a criminal enterprise?
I'm not sure offhand there's precise differences. I think they share a lot of the same elements.
And it seems to me, though, that a criminal enterprise has to be something different, right? It has to be some type of aggravated conspiracy in a way, more than just this agreement among parties to engage in a criminal act or to further a criminal purpose, which is my understanding of general conspiracy. So what is it in the criminal enterprise statute, and how is that here? Which most of what I hear you saying, to me, I would think, yes, this is some type of conspiracy. How is this a criminal enterprise different from what we understand a traditional agreement to further a criminal purpose to be?
I would point to 2 things, Your Honor. First, the criminal enterprise statute requires that each defendant be convicted beyond a reasonable doubt of 3 predicate acts with either employed by or associated with the enterprise and with the intent to participate in the enterprise's affairs. So there's that requirement of 3 predicate crimes. The second thing I would identify are just the other factors that distinguish this case from Western Express to kind of get back to Judge Rivera's question and show that this was that this enterprise possessed all of the features of a distinct entity that existed continuously over time. And here I'm referring to things like rules.
I think that first part, the conviction of 3 separate crimes goes to really the level almost of participation, it seems. But the amicus brief here proposes a test, a distinct structural requirement separate and apart from the illegal activity. Would you agree that that's a valid test?
Yes, yeah, the enterprise by statute has to has to have an existence that goes beyond the mere
beyond those
incidents.
3 crimes and what you need to participate in those 3 crimes, right? In this case, it would be.
Yes.
Okay.
And so, for example, here, we're talking about things like rules and procedures for decision making, and those can be either things like a hierarchy or a leadership structure, or they can be any kind of collective decision making or system for resolving conflicts. And as we go into our brief, and a couple of incidents of competition or conflict arose, and the members had a system for resolving that. And even the case detective, McGuire.
So in that example, all of the participants are on the same level? They have equal authority amongst each other? And there's no one else involved who's, for lack of a better way of saying it, an underling or someone inferior to them?
It's true that there's no one in the enterprise with the authority to command, but it's not true that there aren't some members who are more important. And these are really the distributors like Paul and Dow and miners.
But how does that square then with Section 460? That has all that language about leadership and the Cosa Nostra families. It's not limited to those families, of course, simply because we're aware of, besides the mafia, there are other kinds of these criminal enterprises. How do you square the way you're looking at that with that kind of language, which is in the findings and so integral to the statute?
So the more influential members of the enterprise were removed from some of the street crimes. They were not the ones.
I thought that Paul and Dow were the first ones actually to be approached by the undercover.
By their own admission, they had been in this business for up to 5 years, and so I don't know that characterization is entirely accurate. Although the undercover ended up doing business with them.
So I guess you're talking about protecting them and them being removed, but I don't see that. Maybe they're not the ones going out and stealing the motorcycles, but
yeah.
I just.
Just to finish my answer, so they are removed from some of the most dangerous street crime, but beyond that, the enterprise, the entire structure of the enterprise existed to limit the exposure of its members, and especially of its senior members, by adopting the basic groundwork of, and this again goes into why this is so completely different from Western Express, of placing orders in advance and telling the procurers, the thieves, which motorcycles to steal so that they didn't have to have them around any longer than necessary and avoid the risks that otherwise attend long-term possession of stolen property. They also took more specific means of avoiding detection, such as employing tail cars to follow police cars, such as using lookouts when they were engaging in criminal activities. And like I said, the distributors were not the ones riding motorcycles to the buy locations, nor were they the ones lifting motorcycles off the street, which were the most dangerous parts of the criminal activity. And so they were shielded from view in that regard as well.
Thank you, Counsel. Mr.
Thank you.
Danner?
Thank you, Your Honor. At least 3 points I'd like to try to get to. First, the respondent has done this now in his brief and again at the argument. There is no evidence of a system of authority here, and trying to conjure one on this record is completely impossible. I'll start with what Dawson, the lone cooperating witness, testified. Now, the question. Now, was there anything like a boss or a hierarchy or anything like that? Answer, no. There was no boss. Everyone was working at your own free will, I guess. Later, question.
The problem is, I agree with you about the record, but the problem is that the argument is not that you need a hierarchical structure. The argument is that the structure has to be ascertainable, and it can be ascertainable without being hierarchical. And that's what I struggle with.
Sure, and I heard a few questions about, well, what about this non-hierarchical system of authority? Can there be such a thing? And perhaps the concern is this court's dictum in Western Express, that it may be true in theory that an enterprise need not be hierarchical. That's not even a dictum. The court went on to dismiss the indictment in that case. And it didn't say it is true that you don't need a hierarchy. It said it may be true. This court does not go out of its way to decide questions that aren't presented. So there's no impediment to this court holding now that a hierarchy is required.
What about the amicus test? Would you agree that that's a valid test?
Yes, I think the amicus is a valid test. I take one point of departure. I think what they say is that to the extent that when you're describing a pattern, that is your ascertainable structure, that's not sufficient because it's not distinct. I agree with that. But I wouldn't even get that far because I'd say you don't have a structure in the first place.
Mr. Danner, point 2.
Yes, point 2 is the question about the knowledge and intent, which Your Honor asked. And what we heard was this October 4th bike. And they say, well, Jones wasn't there and Dawson wasn't there. So, they want you to infer from this that Jones must have been more involved, maybe directly connected to Dow. But we can't make inferences contrary to fact. Dawson testified that Jones needed Dawson because he couldn't get in touch with Dow. And Dow needed Dawson because Dow couldn't get in touch with Jones. The fact is that Jones's only connection to this enterprise is via Dawson. And Dawson, who testified for the prosecution in exchange for leniency, didn't put any of the requisite knowledge on Mr. Jones. There is no proof that he knew anything other than that there are buyers of stolen motorcycles out there and Dawson can put me in touch with them. That is not knowledge of the overarching criminal design required under the statute. And the third point, Judge Garcia asked, what's the difference from conspiracy? One of them is the knowledge requirement. There's a very specific knowledge requirement added in addition to RICO's, requiring specific knowledge of the nature of the enterprise's activities. That's lacking here. Another difference, conspiracy to commit an E felony, which is all that's at issue here, is an A misdemeanor in this state. Enterprise corruption, a B felony, punishable by up to 25 years in prison. There is no way the statute was intended to wrap up conduct like Mr. Jones's into a B felony with such a severe sentence.
Thank you, counsel.
Thank you.